subtracted from your final amount of credit. Okay, but you don't really want to do that because it's going to screw up your ethics credits. This program is accredited for 3.25 credits. Of that, 1.0 is enhanced ethics credits. If you do not stay for the duration of the program, for the entire program, you won't get any ethics credits. That's because this is a mixed program. So there's no way for us to actually subtract them out. It becomes too cumbersome for anyone to figure out. So you must stay for the entire program if you want the ethics. If you leave early, you'll just get the regular credit, regular credits. Please remember to put your phone on mute, but if you need to step out, try to make it less than 5 minutes. There are restrooms across from the elevator and vending machine down there. You are allowed to have food and drink in this room. But please make sure you clean it up because I don't have like an assistant that helps me, and I'm expected, otherwise they get really mad if you leave the room dirty. They even suggested one time I clean the chairs up and I said no. So we're ready for our program to begin. This program is called Rule 61, a guide to representing post-conviction clients. First speaker, Patrick Collins. He's going to introduce himself, I think. And the second presenter will be Kathleen Davila, which is known to a lot of you. She now is with the Office of Disciplinary Counsel. So welcome, and we'll start.
All right.
Is it working?
Can you guys hear me in Kent and Sussex?
Let me turn the volume.
I don't really think we need it in this room, but
It doesn't pick up on the video otherwise.
you
Is
guys
it on?
good?
Yeah.
It's on. I'll move it up. Hello, everyone. I'm Patrick Collins. Most of you I know or know me. This is a guide to representing post-conviction clients, Rule 61 cases. Everyone's aware that under the amended rule, as of May 2013, all first-time Rule 61 filers that file within their year get a lawyer to represent them throughout the process. And anecdotally, it has even gone beyond that. I mean, I've been appointed to cases that are on their third or fourth post-conviction, and they're also late and all kinds of other things, but counsel have been getting appointed anyway. So there's a lot of post-conviction cases out there, and will continue to be a lot more post-conviction cases, which is why we're here today. It used to be, as you probably know, it used to be that appointment of counsel was in the discretion of the judge, and so counsel would rarely be appointed unless it was a capital case, first-degree murder case, or the judge thought there was something that warranted the appointment of counsel. What we're hoping to do today is move very quickly through the rule part of it, go through the basics of the rule, as well as what the obligations are of post-conviction counsel within the rule itself, and then spend most of the time on the next two things: how to do a post-conviction case from the day you get the appointment all the way until the time you're out. And then I'm going to go through, if time permits, some initial filings, motion to withdraw as counsel, amended motion, and a little something on appeals, if time permits. But then I need to clear out because Kathy Davila from ODC is coming to talk about ethical related issues. So if anybody has any questions or comments to make, please interrupt me, and we can address it while we're talking about that particular topic. Okay, the rule, a couple things about the rule. First of all, it's the only people eligible to challenge their conviction are people that are in custody or subject to future custody. We have a couple of clients that are currently on probation, and but technically they're subject to future custody on the case, so they are eligible to file. It may not be the smartest thing to do, but they are eligible filers. And this is the rule that permits a person to attack their conviction collaterally, meaning beyond the scope of the direct appeal, it's a very broad rule. They can assert anything they want that is a legal or factual basis to attack their conviction. As most of you know, the vast majority of the time that constitutes ineffective assistance of counsel, but there are other things you can assert as well. Nothing stopping you from doing that. I will say that this is the first time, generally speaking, that you can assert that your lawyer was ineffective. There have been some outlier cases, one of which is a very recent case called Dobson from Sussex County, where the Supreme Court said, you know, when the ineffective assistance is so egregious, we can deal with it on direct appeal. But 97 times out of 100, your first chance to assert ineffective assistance is via this rule. But the rule is narrowed by bars to relief. This part of the rule is kind of arcane, and I wasn't even really going to talk about it, but on the other hand, every time we've ever filed anything in Rule 61s, the state's immediate response is that the claims are barred for whatever reason or another, and it's usually one of these bars to relief. So it is worth going through them quickly so you have an understanding of what they are. Also, when the court writes an opinion on a Rule 61, the first thing they always address, as you know, is whether the claims surpass the bars to relief. So it's a broad rule that's very much narrowed by the bars to relief. And when we file an amended motion, we have to take care to make sure that we explain why the claim is not barred by one of these 4 bars. First one's, and this is Rule 61I1, that's what that is. It's the time limit is a year. It used to be 3 years back in the day. The statute was changed at some point. I can't remember when. Final judgment is defined as the sentence if there was no appeal, or if there was an appeal when the mandate issued from the Supreme Court back to the Superior Court. That's the date, a year from that date. And then the other reason you could beat this time limitation would be if there's a newly recognized right. The most recent and probably most well-known newly recognized right is in the Vicky Chow felony murder case. The difference between during a felony and in furtherance of a felony for the felony murder statute, that was considered by the court to be a newly recognized right. There was just, there's some question in my mind as to whether the right to counsel on a Rule 61 is a newly recognized right, because every time the Supreme Court gets a Rule 61 that doesn't have a lawyer, they remand it back. I mean, we have a lot of remands in our office. I'm sure the other people that do these have remands also. And the case on that is Holmes versus State. And in Holmes versus State, it was the first one of these. A lot of cases were stayed pending a decision on Holmes versus State, and all these are outside the scope of this new rule. They go way before May 2013, but in all cases I'm familiar with, they've been given a lawyer in the interest of justice. So I wonder if that's ever going to count as a newly recognized right, because then you'd have a bunch of Rule 61 people refiling saying this time I deserve a lawyer. I will say this, on January 9th, an opinion just came out. Justice Ridgely wrote it. I shouldn't say opinion, it was a very short order. And this guy, Riley versus State, did file a second post-conviction motion saying I should get a do-over because I didn't have a lawyer in light of the new case law, etc. And that was denied. But if no reasoning was given, it just said we're going to deny it. So there never really has been an opinion yet as to whether the right to counsel in Rule 61 is a newly recognized right. But that's the time limitation. The next one is repetitive motions and claims are barred. In other words, you're allowed to file as many post-conviction motions as you want as an inmate. I mean, there are, I'm sure you're familiar with some that are on their 7th or 8th post-conviction motion by now. You can't refile the same claim, and you also can't repackage a claim and try it again in a different sort of way or a different So, to propose a legal theory, it's going to be barred because you only get to raise each claim once. There is an exception to that, interest of justice. I'll get to that in a minute. The next two are much more serious, and we have a lot more to do with. One is the procedural default.